Hello everyone and welcome to today's Mondac webinar in association with Lindemann Law, who will be providing a comprehensive overview of escrow services and highlighting their importance in safeguarding various types of transactions. We have a brilliant, diverse audience of professionals with us today from all over the world. So good morning, good afternoon and good evening to everyone joining. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Alexander Lindemann is the managing partner at Lindemann Law. With a robust background in legal, regulatory and tax advisory services, Alexander specializes in investment funds, asset management and financial structures such as securitizations, holdings, foundations and trusts. Additionally, he is experienced in international large-scale transactions in real estate, M&A, blockchain, art, brokerage and escrow services. Lionel Serex is the head of litigation at Lindemann Law. Lionel heads the team's litigation practice in civil, criminal and administrative law, representing clients across Switzerland and abroad. With over 15 years of experience, he excels in handling complex domestic and international litigation, regulatory and compliance matters. He also specializes in commercial and corporate law, with additional practical experience in escrow services for real estate transactions. Tania Ster is the head of escrow services at Lindemann Law. Tania specializes in international private law and art law, offering extensive knowledge and practical insights to her clients. Tania's expertise includes art escrow, M&A escrow services, and AML compliance, enhancing her ability to navigate complex legal matters. Tania is known for her strategic thinking and dedication to client success. And completing today's panel is Tania Davidoff. Tatiana is an equity partner at Lindemann Law. With more than 30 years of working experience, Tatiana advises clients in regulatory matters, cross-border and compliance issues, and AML policies. Further, Tatiana advises in financial and capital markets law, fund law, M&A, real estate and relocation, as well as blockchain and technology law. Tatiana also sits on selected boards of directors. Now, before we begin today's webinar, a quick housekeeping item. You can submit questions to the panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible during our Q&A session and throughout. It's now my pleasure to hand you over to Alexander to begin. Thank you.
Thank you, Dan. Hello, everyone around the globe. We are very happy to have such an interesting and diverse audience that reflects actually also our clientele. We have clientele and clients from all continents, and that makes us very proud. Walking you through the agenda, Tania Davidoff will explain. She has a background as a global compliance head with HSBC, so she will walk you through the intricacies of the banking environment and the particularities of escrow accounts and what parameters are included. I will then follow with a brief roundup of all risks, essential risks that are involved in real estate transactions, M&A transactions, blockchain, art, and brokerage transactions, as well as how escrow services can protect you from such risks and how they can be designed properly. We will then deep directly into case studies to show you some flavors of how escrow works and what can also go wrong without escrows. In the end, then I will elaborate some trends, and we will then directly dive into the Q&A, and we already look forward to have a lively discussion with you. You can already start to submit your questions in the Q&A function. Tatiana.
Hello, everyone.
Have worked with escrow already in the bank. Now you work with us in the law firm for a number of years. And yeah, we look forward to your description, how this works.
Thank you, Alexander. Hello, everyone. And let's demystify what escrow account is. Well, escrow account, as you can see on your slide, is a type of block account which is established and managed by the third party, normally a lawyer, for buyers and sellers in order to facilitate the deal. The function of a lawyer in this case is called escrow agent. And the funds which are on the account are of course separated from escrow agent's own funds. These are not the funds of the lawyer, they belong to buyer, to the seller, to the buyer. Well, why do we need an escrow account? Escrow agent plays an imperative role in facilitating and securing the transaction. Escrow agent is normally trusted by all parties, the bank, the buyer, and the seller. The parties who are involved in the transaction engage the third party, typically a lawyer, a law firm, under the escrow agreement to temporarily hold an escrow funds to provide certainty and confidence that all parties meet their obligations. Normally, escrow services demand and solve the issue who acts first, the buyer, the seller, are the funds revealed first, is the asset released first. These questions are solved by having an escrow account and escrow arrangement. Next slide, please. So the role of escrow agent, the most important role of the escrow agent is impartiality. The synonyms, the keywords are here, neutrality and independence. The reason why the lawyers are usually the good fit to be an escrow agent. Lawyers are impartial, law firms are impartial, thus they are the best escrow agents. Second, the most important feature are infrastructure and expertise. So lawyers acting as escrow agents obviously have access to the banks and long-standing connections and professional ties with the banks. They are trusted by the banks, not only by the buyer and the seller. They know the regulatory framework, which is very important. This makes again and again escrow agent as a lawyer the best fit. And last but not the least, very important, compliance with legal regulations. It's vital important to emphasize escrow activity is a regulated activity. Thus, the best fit for an escrow agent is again lawyer or a law firm. Why? Because all the requirements of the due diligence, anti-money laundering, and KYC are not in this case conducted by the bank, but are trusted to the escrow agent, which is normally the law firm. And this whole setup makes the whole deal more confidential. That's not the last thing for the buyer and seller. Normally, deal is a very confidential thing. Next slide, please. Well, how are the escrow accounts structured? There are three very important parties: the buyer, the seller, and the escrow agent. The banks normally play a role of a depository bank. Well, the depository is the seller, the one who places funds on the account. The beneficiary always will be the buyer, the one who eventually receives the assets, and the escrow agent. If we look at the structure of the escrow deal, then there are several very important points. First, the assets needs to be described, description of the assets. Next, the most important thing is deposit period, for how long you deposit your money on the escrow account in order the deal to take place. Release conditions is utmost important thing. Why? Because these are the modalities, the triggers under which the deal actually happens. And last but not the least, obligations of the escrow agent himself. Other things could be included like hedging modalities, etc., to facilitate the thing while it takes place. Next slide, please. So the takeaways from my part are the following. In order to choose the right escrow agent, in our case, we recommend, of course, Swiss law firm, our firm. Why? The takeaways from me to you, the following things can't be underestimated. Legal expertise. Lawyers have thoroughly understanding of the underlying transactions. You don't accompany a deal which you don't know or understand. We do.
Just say something, Tatiana. I mean, we are working on both sides, right? I mean, we are working for the clients on such transactions, but we're also working impartially as an escrow agent. So, I mean, we know both roles. So that typically has.
Yes, this will be, thank you, Alexander. This will be clear in one of the next examples. Thank you. So impartiality is the role of the escrow agent himself, and trustworthiness. Okay, the lawyers are normally bound by high ethical standards and professional codes of conduct. That's more or less same in every country, that these codes need to be adhered to. Problem-solving skills. Many things can go, if not wrong, then just unexpectedly arise during the deal, while the deal is still ongoing, taking place. There can be some disputes. Again, the law firm is the best fit to solve the problem, to take, to accompany any negotiations, and during negotiations, which is very important, during the time where deal is still ongoing, taking place, to find a solution. Normally, when deal is on, one has no time to interrupt, to go to court. Things should be solved. Any issues, any problems arising should be ongoingly solved, and again, the law firm is the best fit. And also, the law firm can provide comprehensive services. One of the things was mentioned already by Alexander. Escrow agent is always impartial, but you can have a lawyer on your side as a seller or the buyer. That's something else. We will talk about that later. And this also allows you to reduce the costs. You do not need to hire, again and again some consultants. All you need, an escrow agent and possibly a lawyer on your side, which is a different entity, but that does not have any conflict in it. So these are my takeaways for the moment.
Thanks a million, Tatiana. I will now start my part with the next slide, the Aaron, where we get an overview of all the risks involved in such large-scale transactions. So we'll start with real estate. As I said, I mean, we work in real estate transactions on both sides. And I mean, when you have such a huge residential or non-residential real estate transaction, then there are, for example, issues like foundation issues, right? There are issues, the heating system, the electrical system. There are hidden defects. There are things that need to be inspected and repairs to be done that you detect in many cases only after you have full access to the real estate. So here the escrow agent has the typical holdback function. So we can have the money sit in our deposit, and while the buyer has enough time to really do his inspections or the seller still can do the repairs. So these things can be done while the money is already safe in the escrow account. We have, of course, title defects. And title defects, what it means is, you have mortgages, right? You have mortgages in the real estate registry, and you have also loans that may be not in the real estate registry, but they are otherwise connected to the real estate. And if you have, of course, legal claims that have a special attachment to the real estate, and all these title defects also need to be monitored and inspected and detected before the escrow agent can then disperse the funds, right? So the title need to be clear. Third important is contractual obligations. Of course, I mean, the financing needs to be secured. I mean, and that later Tatiana will talk about only when the money is then really in the account, you know, that it's there, right? So securing the financing, that is one of the major obligations of the buyer, but even from the seller side, there may also be like important repairs or other important work that needs to be done. Regarding then M&A, it's also classical escrow. They are undisclosed liabilities that need their time and not always in the due diligence already fully be seen. They may be seen in the first year or two. So there may be hidden debt, pending lawsuits, regulatory issues. For example, I mean, we are involved in banking transactions. There may be regulatory issues that our buyers find out. So here, indemnity escrow can be a solution. Otherwise, of course, there are a number of representations and warranties in each SPA regarding business conditions, operations, and these statements may be inaccurate or false. So this, you want to have enough time and an impartial a person that helps you to verify this from both ends. Failure to meet post-closing obligations. Of course, there may be milestones, financial and operational milestones. There may be earnouts. And these things, I mean, as it already says, there needs to be a holdback in the escrow. And on the other hand, yes, you want them already have in the escrow so that you can be sure that they are paid out if you meet these conditions. When we go to the blockchain, typically, I mean, there are three risks. It's about a lot about vulnerabilities of the programming itself, coding errors, bugs, vulnerabilities, malicious actors. But we have also, of course, the market volatility, and that can then lead to financial losses or disputes between the parties. But while the transaction is being processed, or within 24 hours, the market can dramatically change, or that might lead then to uncertainties that can be. There's more stability and more reliability if the assets and or the money in the escrow. Of course, in this area also we see fraud and counterparty risk. As an escrow agent, we have the means and intelligence to identify the trustworthiness of the counterparty, and so both parties can also rely on such an additional layer of safeguard. Regarding art, art is something that we, of course, like because it's beautiful paintings, beautiful objects of art. But sometimes they don't have the provenance that they are supposed to have. So they may be forged, or they may actually misattributed. Also, even in cases, they may be rightful, the owner, the authenticity, the provenance may be right, but it is not properly documented, so there may be doubts, and you may need time to recover and to get such verification of improperly documented provenance. So there, the escrow has once more like a holdback function and forensic for the forensic analysis and the provenance research. We just have a case with such in this area. That will be presented later, right, Tania? So title disputes, ownership claims, of course, with an object of art, it may be actually inherited, it belong to somebody else. It may actually just be loaned instead of fully owned by the person that sells it, or it may be even fully be thefted. So these things may be attached to an object of art. So this also can be cleared with a proper documentation and with a certain waiting period in the escrow. Of course, when it comes to art, but it's a general topic for escrow in general. Of course, the money laundering compliance is something which we as a law firm are used to, and we have the intelligence for this, and we know the rules, and we can make sure that such a money laundering compliance fully adhere to. When it comes to brokerage or Paymaster services, we have large transactions like oil and gas, like sugar, like wood, whatever, where also the provenience of the money is a big topic. So here, money laundering compliance is a major issue. Then also, of course, a big issue is the volatility of such assets. They may go up and down rapidly during the transaction, so that might lead to conflicts. But if it's already in the escrow, such conflict should be able to avoid. Liquidity risk, of course, you have counterparties in the brokerage. Counterparties may not be able to meet their financial obligations in time. They may have to sell for an unfavorable price, maybe, and may even forced to be liquidated. So these are all risks that you can avoid with an escrow agent. So with all these, with this overview over the asset classes that we typically see in our escrow practice, I would run you quickly through the process of how the escrow works, the 5 steps. First of all, we start with a transactional document that is typically already like drafted, or typically is in a draft statement when the clients come to us. So we review it, and based on that, we draft then the escrow agreement that is signed by both parties. It's a triangular, typically, agreement with buyer and seller, where we act as an independent, impartial escrow agent. We, of course, then look into the AML. We ask the buyer to deposit the money in the escrow, and then actually the escrow, the second part of the escrow worked. We we have to perform the second part, which is like we have defined all the conditions in the escrow agreement, and these conditions then we will check one by one, and then release the relevant tranches or the full amount. As a final comment on slide 39 already, before we go into the case studies, the fact that we as a law firm and law firms in general already also work in the transactions itself and know how to draft these documents, of course, is helpful. And as we have a different expertise when it comes to banks also, or financial intermediaries who might work as escrow agents, there typically there's different areas of expertise, whereas we as lawyers have, of course, a more focus on such legal pitfalls. Tatiana, you have done a number of mergers and acquisitions. You're presenting us now a M&A transaction. I think it was a bank, right? Or what was it?
Thank you, Alexander. I'll describe the following very exciting case. So M&A transaction, merger and acquisition, very popular, a heavyweight. So there was a financial institution in an EU country which was acquired by a Swiss entity, and it was quite a heavy deal, 300 million Swiss francs. That's a heavy deal. And here to explain to you, that was we mentioned before, was me and Alexander. Don't mix up, don't misunderstand us. The escrow agent is always impartial. That's a law firm which is chosen to be impartial and be an escrow agent. The escrow agent does not take sides. However, the buyers and the sellers, they could of course hire their own lawyers, and because this deal happened long ago in the past, there was an escrow agent, which was a famous law firm, you can guess which one, and at the same time I acted on the side of the buyer to accompany a sales purchase agreement. So if we go to next slide, please, for everyone. Yes. Here, crucial thing is, and it's crucial to understand, escrow account is a block account, as we mentioned before. In this case, 100 million was already deposited to the account. Now you ask me what is the difference with a common case, sometimes buyer and seller, when they are kind of not amateurs but trust each other, and they just say, okay, I buy from you something, just show me you have got funds. So the other party goes, the buyer either, sometimes people can provide, and that's quite often the case, a fake a statement of the fund, or even if it's not a fake, very often somebody can come bring you, yes, here I have 500 million deposited with such a bank. Per se, this does not give confidence for the deal. Why? Because simply availability of the funds somewhere even if it's a reputable bank, do not show the commitment of the buyer for the deal. This is very important to understand. If two individuals are serious about the deal, and especially the buyer has to deposit normally certain amount of money, not always, but normally certain amount of money on this block escrow account to show that his interest to purchase the assets is genuine. That's why we emphasize that having 100 million already on this blocked escrow account showed that the buyer is an absolutely serious person. My colleagues will bring other examples. Money on the account normally is a guarantee for lots of unexpected things during escrow transactions. I mean, simply having money to resolve some issues, it's always good. So this prepayment showed the necessity and the usefulness of the escrow transaction, escrow deal itself. And thanks to this, the transaction went very smoothly. And we are proud that, well, I'm proud I accompanied the buyer, but on the other hand, escrow agent was very proud to be, a law firm which accompanied the deal. This is a takeaway from my side, and I'm happy to answer further questions in this regard.
Thank you very much, Tatiana. Very interesting case study. Lionel, you had our litigation practice, and there are some interesting cases as well, right? This real estate transaction that you show us today is a masterpiece of real life.
Yes, absolutely. Thank you, Alexander. Hello, everyone. So basically, we had this court case which involved a buyer and seller who concluded a promise to sell a house in Switzerland. Buyer was living abroad, foreigner not living in Switzerland. So there was documents to obtain from Swiss authorities to conduct the transaction. The seller was a Swiss citizen, and as it was a real estate matter in Switzerland, you have to designate a notary who will prepare the draft contracts and act usually as an escrow agent. And in this case, the escrow agreement was included in the promise to sell, so that it was not independent. And in this sale agreement, there was only two provisions relating to the escrow. And the first one provided that the buyer had to pay 10% of the purchase price to initiate the negotiations, and that the notary should keep this amount until the final deed of sale had been entered into between the parties. And in the end, the notary would release, after full payment from the buyer of the total purchase price, the amount to the seller. The second provision in there was this resolutory condition, whereby the promise to buy and sell would become null and void if the buyer, within 6 months as of the date from signing of this promise to sell, had not obtained documents such as a residency permit and an authorization from the department of the city where the house was located to acquire the real estate. At the end of this 6 months, the buyer had only obtained one of these documents, which was the authorization to purchase the house, but not the residency permit. And then a dispute arose, of course, because at the end of these 6 months, the buyer to the notary and said, okay, uh, the transaction is null and void. Please pay me back the 10%. Whereas the seller said, of course, the contrary. He said, no, you obtain one of these two documents. So the promise to buy and sell has to be extended. And so you had the notary in between them, and the seller even filed a freezing order to the court to avoid that the notary public releases the money to the 10% to the buyer. And this case is still pending. We are now on the merits to see what will happen to this 3%. So in the end, we see here that the issue is really that the escrow clauses were drafted too broadly. They are not. There is no separate escrow agreement. It's included in the sale contract. So the notary didn't really maybe pay attention to them. The parties as well didn't check or verify what happens exactly if at the end of this 6 months you don't have one of the documents. And then you have a dispute. You have to go to court because the parties do not agree. They are not willing to find an agreement. So it's typically the case where we would recommend not to wait, and you could involve even, and I think it's one of the questions already in the chat. If you have a notary acting for both parties, I mean, as a party, buyer or seller, you should be advised independently by an escrow advisor to check this and to make sure that the consequences are described, because otherwise then you have to go to court, and it's costly and it takes time. I mean, the proceedings is the last thing since now. So I think it's a good example of real estate case. So, and if you have any additional question, we may respond later, I think.
Thank you very much, Lionel. So, eben, what can go wrong without a proper escrow expert? In this, also, Tania will now come in with an art transaction, quite an international one. I'm curious to learn more about you, about this, Tania. Please, the floor is
Thank you,
yours.
Alexander. Thank you, and hello, everyone. So the case I want to present is a cross-border case where the seller and artwork were located in the US and the buyer was located in Europe. The party came to us already with the signed sale purchase agreement, which envisaged that seller has to provide expert authentication report to buyer, and after 2 weeks, the money have to be released. So that was reflected in the escrow agreement. The seller submitted us the report, and according to disbursement mechanism provided in the escrow agreement, we released the money. However, the seller was not happy with the expert. So he wanted that the buyer was not happy with the expert, and he wanted that the seller provided another expert opinion. but escrow agreement was already terminated, fund released, and the party had to solve this issue out of the escrow transaction. So our recommendation to apply to legal advice on the stage of drafting sale purchase agreement. It's important to very clearly in detail envisage the disbursement mechanism. Special attention has to be paid to who provide the authentication report, who provide the conditional report, at what point of time, provenance of the artwork. Some other important questions: where the artwork is stored during the life of escrow agreement, who covers these expenses, transportation, insurance, how the cost will be shared by the parties. All these questions really can be discussed with your escrow agent and in duly manner established in escrow agreement and sale purchase agreement. So we will be happy to assist you if you would need our help.
Thank you, Tania. So I would like to now turn to the blockchain and crypto assets. Here the field is moving. That's a young discipline, right? A younger discipline. We were involved recently in a quite nice transaction regarding Bitcoins, one of the major cryptocurrencies with an equivalent value of more than 550 million US dollar. And this transaction also actually involved a buyer from New York, where he wanted not to buy it just on a simple stock exchange or crypto exchange because of the price volatility, right? So he wanted a private market because such a demand of such a considerable amount directly changes the price on any crypto exchange. Here in this area of crypto, the fundamental question that we have to answer here and to discuss with the question is, do we want institutional wallet? And there in Switzerland, already a number of banks have such institutional wallets. Major providers that we work with are like Signum Bank, Amina Bank, former Seba Bank, and Bank Frick. On the other hand, many business partners in this area actually prefer the more confidential, as you said, Tatiana. They prefer more confidential, and they don't believe so strongly in these institutional partners. So they prefer to work with like private multi-signature wallets. So this fundamental question in this case was actually answered yes. They wanted a multi-signature wallet rather than such an institutional, and this also of course then faster. We did work with, however, with a very reputable provider for intelligence that provided us for the bitcoins, checked these bitcoins like till the end, till the mining, all the way up, and we actually detected in this transaction then some mixers that actually led to the fact that the client actually said, no, actually this is not the bitcoins I want to buy, because later if I have them in my wallet, it will be difficult to use them. So the question of Satoshi test here actually didn't come into play. It's also fundamental questions. Some partners believe in the Satoshi test to verify really the address, but others are afraid of the risks that this can be lead to cyber attack or to loss of the Bitcoin. So these fundamental questions from the case study, from several actually cases combined to one case study. And last but not least, even Paymaster and brokerage. Here also, we just had this morning discussed about such a transaction in our office. Had a client here in the oil and gas business. We had a case at 1.2 billion US dollar. That's not the largest amount we had. There's just a combination, like a team of brokers were involved in this to bring this deal together. So they were like around 10 parties involved as brokers, and they all wanted to participate in the cake. So the brokerage fee alone for this deal was like around 80 million. So what is important in this constellation of Escrow and Paymaster is you have a huge deal that is being cleared with an escrow agent, with a bank, and then you have a smaller deal where a number of parties are involved, number of brokers may be involved, but that basically needs even more, right? Even more KYC work, because in addition to the parties themselves, there also is to be done the KYC for the brokers. So there's even more work. So here, actually, what we did in this case, we managed to open the Paymaster account. Also, we managed, first of all, to get all the KYC that had been already done for the deal itself, for the opening the escrow account. And with this, it was then easy for us to make an attached escrow account for this brokerage deal, for this brokerage amount that still considerable amount of 80 million, but of course considerably lower than the full transaction of 1.2 billion. Before we go to the questions, just some outlook. That's a slide. Yeah, that's the next slide. Thank you, Aaron. We have a number of digital and technical issues that improve the services in our area. We have, of course, blockchain itself and artificial intelligence that helps to streamline the services. We have mobile accessibility and customer support that enhances the user experience. We have, of course, more actually escrow assets and payment assets in the digital area and the non-traditional assets area, so-called alternative assets and digital assets. So there we have, we see a lot of development, and it's very exciting. We have, of course, like digital means like compliance automation and automated GDPR compliance that helps a lot in our work. And of course, more and more also becomes relevant is the sustainability and ethics topics that also add for additional layer of compliance. When it comes to the key takeaways, what we've seen from Tatiana's case is, I mean, the escrow allows that for such a big M&A transaction, already 1/3 or more of the money is on the table for the negotiation, that we really see the power. I mean, not just a document that may be true or false, but really has the amount on the escrow that really shows the willingness to acquire this bank or this asset. So that is a factual and practical issue that really helps. We have seen how important it is to really define the conditions when the asset or the money may be cleared and may be forwarded by a notary or by another escrow agent. So this is really requires expertise and skills to define this properly and foresee potential conflicts. We have seen that it can be useful to have an impartial escrow agent to add an additional layer of safeguard regarding all the due diligence and other checks. And of course, it creates trust also between the parties, the transparency of the communication. You feel like a transparent communicator who can confirm the money is there or have viewing rights. And all this transparency helps, of course, to create trust and facilitate the the large-scale transaction. So thank you very much from my side and from our side, and thank you very much for the team for all the case studies. We have a number of questions as I see then. So could you moderate this Q&A session, please, Dan?
Of course, my pleasure, Alexander. And before we move on to the Q&A section, I just want to say a huge thank you to our panel today for their insights. It was a fascinating discussion, so we really appreciate your time. And yes, we have a number of questions in from the audience. I'd like to start with this question, which was actually sent in before the webinar, started. And let me just find that question for you. As per Swiss law, can a Swiss resident individual become an escrow agent if all parties agree and it's recognized as such by the banks?
In this case, is not being a lawyer notary, right? That's the second part. So I would like to hand over this question to Tatiana. You have worked as a global compliance officer for International Banking Group. What you see this? Do the banks, what's their role? Can they decide over the escrow agent, or what's advisable in such a context?
Thank you, Alexander. Certainly not.
Nature, yes. Is that also could it be good solution?
Yeah. Thank you, Alexander. Thank you, everyone, and thank you for the question. Certainly not. The bank is not a party to decide for whoever, buyer, seller, who will be the escrow agent. That's absolutely out of the question. It's not the bank's job. They would not probably even take the risk to recommend somebody going for knowing Swiss banks, because that's not their core activity. So once the escrow agent is chosen, yes, we said the question was whether individual can become and can be recognized. Well, theoretically, and only theoretically, any individual can become an escrow agent. But in the practice, it's very highly unlikely that escrow agent will be just an individual. We mentioned before why, and the reasons are, first of all, thorough knowledge. It's a regulated activity to be an escrow agent. You need deep understanding of laws, regulations, AML. So in this case, the banks would trust the law firm, the lawyers, and the clients, of course, will trust more the lawyers, unless, you can go and do any deal on a handshake, or you can invite your third friend to participate in this handshake, but that will remain then a handshake with the consequences of a handshake. And if you want really a serious deal, and we had many examples today of cases which can go wrong and things which went right, it's highly unlikely that individual will be accepted by the bank, and certainly not recommended by the bank.
Thank you very much for that answer, Tatiana. What is the industry accepted practice in relation to due diligence for service providers holding escrow accounts?
Yeah, I think that's maybe another question for you, Tatiana. Would you like to take one as well?
Gladly. So, well, we mentioned before AML, we mentioned before knowing laws, regulations, we mentioned it's a regulated activity. I repeat myself, but these are important key points. Well, if a lawyer, and most of our lawyers, all of our lawyers have worked before, a very responsible job. I was, for example, in the center of competence with the bank. So this experience in a center of competence makes you a real expert in lots of laws, regulations, etc., etc., etc. And it's an ongoing improvement. We update ourselves daily on the change of regulation. That's also very important. And then going back to the previous question and answering this question, no individual is capable, to update himself daily on lots of laws and regulations. As a lawyers, we get, of course, daily information more or less on these updates. So basically the knowledge, know-how is here, and it's a joint know-how of all our lawyers who worked in various functions. It's a common joint experience of all of us, and that makes, that's a know-how basically.
Brilliant.
Next
Thank you.
question. Next question. We have lots of questions.
And
Try
yeah,
to answer
we've
all
got
of
a
them.
lot. We've got a lot of questions here. So I will say, if we aren't able to answer your question, please do get in touch with the panel with Lindemann Law, and they will have your contact information as well. Steve asks, would a lawyer for either parties of the contract be an ideal escrow agent in the same transaction, or would that lead to a conflict of interest?
Yeah, I think that. Thank you, Steve. We have already touched this question. That's typically a different role. So typically, there's like two different lawyers. One is for the party, and one is for the other party. And then the escrow agent is a law firm that understands the issues, right, as a law firm, but is impartial because it's contracted. The escrow agreement is contracted as a tripartite agreement with both parties. So that already answered. I actually also for this next questions, do we work with Canadian US companies? Yes, the answer is yes. And we just this morning I had another client that I discussed with some questions in the escrow, and here regarding the costs here involved, we have two parts of the cost. The first, like the onboarding cost, right? Tanya, we have for the onboarding, we have of course we have to check. We have to do the background checks. We have to see where the money comes from. We have to understand the transaction. We have to open and clear the bank account. So that is a substantial work to make it possible. So there we have typically like onboarding fees between 15 and 25K, and then we have a number. We have a number of then when it comes to the transaction itself and like looking at the conditions and checking and monitoring the conditions and holding back. This typically we have an amount that is on a percentage on the assets under management, so to speak, and that's typically a percentage between 0.5% and 2.5%. Then the next question.
Brilliant, thank you. This question from Dimitri. According to Swiss law, are funds deposited into a lawyer's bank account as an escrow agent while the money is in the lawyer's account still considered to be the client's money? Are there any legal provisions that prevent such money from being withdrawn for the lawyer's personal debts and obligations?
I would like to take the first question actually, and then the second I would like to hand on to Diana. I mean, the thing is, it depends really on the transaction. Let me hear. So what was it? Yeah, it depends really on the deal itself and on the payment conditions. So there may be two scenarios. In one scenario, once the money is in the escrow, it may technically already belong to the seller, but in many cases it still belongs to the buyer as long as the conditions are not met. So that really the typical lawyer's answer, it depends, right? So Tatiana, for the second question, I mean, what is this money actually ours when it's on the escrow account? Could we sort of buy some ice cream for it?
Well, thank you, Alexander. Yes, I just take a ball from you. As you said, seller, buyer, but certainly it's not our money. It's certainly not the lawyer's account in terms of it's not our money. We cannot command, we cannot transfer money from this account further to buy us ice cream or other exciting items. Well, normally, typically, one could put as many provisions if buyer or seller are afraid that the lawyer does not take the things away. Well, don't forget the banks are also watching. They are also under anti-money laundering and other, code of conduct. And of course, the bank watches as well. But again, it's with escrow agent, and you do not choose escrow agent as a random person. That's an echo to all other questions previously asked. You choose a reputable law firm. Now what happens, and that's worth to explain, when you choose a reputable law firm, you look also who the people are, right? People are, they have, first of all, you look at the jurisdiction where the law firm is. In this jurisdiction, it's a law law firm. The lawyers work, they have track record. Certainly the lawyers are not planning to run away to some islands, with money from escrow account. The banks will not allow it. The other side, and buyer seller have certainly, they can and they should put maybe some provisions, but normally that's clear that it's already clear in advance also to the bank, as Alexander mentioned, to which account money should go. So it's highly unlikely that during the course of the action, there will be some order from the lawyer to transfer money left and right, to some account which has not been mentioned before. That also comes back to the due diligence, to the meticulous of the whole process, meticulousness, because the accounts of the buyer to which eventually money should go is already normally mentioned, known, etc. So highly unlikely, and nobody will accept such order. It's watched so that we cannot just, suddenly mention any account, and that for this reason you open an escrow account. Now, there have been also other questions I have seen whether one can open another account and another account. Well, that's not the idea. There is one escrow account and it's regulated, and the law firm is responsible, the escrow agent is responsible, and accounts to which money eventually should end up are also mentioned. So that's what we always said: regulated, regulated, regulated. That gives a peace of mind. You also know it's unlikely that us, stand up and run away with our families, etc. So that all makes it very plausible, very credible, us and other agents as a law firm, as an escrow agent.
Yeah, that would be a interesting escrow account where the way of the money would not be defined, and the way is typically either forward to the seller or back to the buyer, right? So there's only these two directions that are possible. The next question, Dan, we have 3 more minutes.
Yes, we've got time for a
3
few more
minutes for
questions.
7 more questions, so let's try to answer it.
Yeah. Ali asks, can digital currency be deposited into a multi-signature escrow wallet?
Yes. Good questions. That's what I mentioned already. There are the two ways, typically like the institutional wallet, but also like the private multi-signature wallet. Both of that we work with, and in many of the times, actually, the clients prefer such multi-signature wallet.
Brilliant.
Next question.
So we've had this question in from Christian. At the beginning, you mentioned that in several countries, the escrow services is highly regulated by governmental authorities, for example, BAFA in Germany. How is the regulatory environment in Switzerland in this context? Is an escrow agent regulated, or do they need a license from the Swiss government?
That's a good question, Ed. This was also some other question goes in the same direction, like what is the industry accepted practice in connection with the due diligence with such a escrow provider. There are like two licenses, right? I mean, it's one on the one end is like the lawyer's license. I mean, lawyers are under supervision. I mean, they first have to get the bar exam, but also fulfill all the fit and proper before they can be registered at the bar. Then they are under constant supervision. So that's the one side. On the other hand, there's like for financial intermediaries, they're typically either directly supervised by the regulator FINMA, or they are a member of a self-regulatory authority in Switzerland, which also leads to like that you have these dossiers, this money law AML dossiers, and that you have like an annual visit, like any other financial service provider or bank. And then, of course, important track record. I mean, when you choose an escrow or paymaster agent, look at the track record. I mean, because that's important, that you're not a guinea pig, and that you know that you're an experienced hands, and the escrow agent has already dealt with such similar transactions, and can give you peace of mind.
Brilliant. Thank you, Alexander. I'm just looking at the time, and in respect of your time and our audience's time, we will need to end the Q&A session there. We did get a lot of questions in. I do advise you to get in touch with Lindemann Law with any questions that weren't answered. They will be more than happy to be in touch with you. Before I hand over to Alexander for his closing comments, I would just like to say from Mondac, thank you to our whole panel today for your insights. It was fantastic to spend an hour with you today and learning about this fascinating topic. So Alexander, I'll hand over to you to close us off.
For me, it just remains to say thank you to everyone. Thank you very much for Mondac, for your wonderful organization and all this professional handling. That was very good experience for us. And thank you very much for my team. Thank you very much for the case studies, on the realized case studies. Very insightful also for me to hear it from you. And with that, thank you very much for all the wonderful questions. Let's be in touch. We look forward to hearing from you. You have all our contacts. And of course, we look forward to work together and have success in the business.